Hello and welcome to the Womxn Show. I'm Lenina Rassool, and today we are speaking about the naming of accused in sexual offences and rape cases before they plead, which is illegal, and how women survivors and their supporters are being sued if they identify perpetrators on social media. Now, the Women's Legal Centre have launched an application to challenge the constitutionality of the Criminal Procedures Act, which prohibits the naming of perpetrators until they plead, and we are going to be speaking to them about that after the break. But before that, we are going to play a video which they produced about organizations who are fighting the fight in the GBV sector. Let's have a look.
When you see something, act, do something, don't look away. My name is Wendy Pakir. I'm the founder and coordinator of Ubuntu Rural Women and Youth Movement. We are based in the outskirts of Stellenbosch, but as an organization we operate in 3 provinces of South Africa, which is Western, Northern and Eastern Cape. As Ubuntu Rural Women and Youth Movement, we have a gender-based violence community response program. So what we do is we have programs on the ground, keep an eye on the child, keep an eye on elder, keep an eye on people with different abilities. So we look out for the most vulnerable people in the community. So when we find children who are supposed to be at school or not at school, children that are neglected, abandoned, children that suffer violence in the home, abuse, their substance abuse, we bring the social workers in, we work with the families to see what we can do to assist them. We make sure that the rights of the child is protected, because we find that most violence happen in the home. The perpetrators are often people known to you, and that is why we have women that's been trained, that do that work on the ground. The same with women with different abilities and also elderly people. We find in communities people get beaten for their SASSA money because the child or the grandchild might be on drugs. And it's to report those matters and to make sure that the families or those that are impacted, the survivors, are safe and that their matters are attended to. We support women with protection orders. We do court support. We will help to complete the forms. We will go to court with them. There's a couple of intimate femicide cases that we are working with, where we support the families of the victims who passed on, where we make sure they have psychosocial support. We go to every court case. We ran petitions to oppose bail. We meet with the chief magistrates and prosecutors to make sure there are justice for these cases. So it's a more holistic approach. We don't only go to court and just do the bail application. We make sure the families are fine. When there's a loss of income, we make sure these families are taken care of. They have access to food and their basic needs are met. What can we as women, NGOs and organizations do to eradicate violence against women? There are so much that we can do. As part of our GBV awareness work, we had a pamphlet targeting men and speaking to men as role models, because we often found that there's a lack of male role models in communities where we want men to stand up to kind of show who they are as men, as gentlemen, and to show other men there's a different way in dealing with women or working with women and children in our communities. And then to change the face of gender-based violence, where we have a lot of men that are against GBV. And I think that is what we want to see more out there, where men speak out against it and work together with women's organizations like ours, Colours Foundation, Women's Legal Centre, and many others, so that we can collectively tackle the issue of gender-based violence. The faith community, for instance, if you look at people that belong, when you look at different faiths, whether it's Buddhist, Christianity, Islam, doesn't matter. Millions of people belongs to different faith communities. The faith communities can play a role by not only preaching religion or convert from the pulpit, but to speak about respect to women, to speak about how men should treat women, to tackle gender-based violence in these faith communities, to tackle inequality and power issues and where men think sometimes think they are superior to women. You know, these things should be taught in faith communities as well. I'm just thinking of the role of schools, where from young ages we need to teach boys how to play with girls, and they shouldn't even touch a girl or pull her hair or touch her in an inappropriate way, because when we start young, you're going to have a much better adult and a different male, because he's going to be taught to be respectful to a little girl and to respect boundaries. Now, you can't teach that when men are already adults. You know, sometimes it do make a difference, but we need to speak young. In our school curriculum, we need to bring these issues into the school curriculum and teach both boys and girls around power issues and equality issues and so forth.
That was a short video produced by the Women's Legal Center, profiling an organization in the GBV sector. We are going to take a short break, but we'll be back with more after this. Welcome back. You're still watching The Womxn Show, and today we are speaking about the naming of accused in sexual assault and rape cases, and women or victims and their supporters being sued for defamation as a result. And joining me in studio to speak about this is Bronwyn Pithey, who is an advocate at the Women's Legal Center, and Chriscy Blouws, who is also an attorney at the Women's Legal Center. Bronwyn and Chriscy, welcome. Thank you for joining us. Thanks very much.
Thank you.
So, Bronwyn, I'm going to start with you. The naming of accused or alleged perpetrators in sexual assault and rape cases has been in the news quite a bit recently, and also been in court. And so there's been media hype around it. We've been on the Womxn Show. And now the Women's Legal Center is taking another step. You are actually challenging the constitutionality of whether we are able to name, whether we should be able to name the accused. And there's a technical thing here. You can't name them until they have pleaded, but pleading can sometimes take up to 2 years. So I want to ask Bronwyn, to give us more background around the naming of, and also why the current legislation is so problematic.
Thanks very much. So we first need to really distinguish between the criminal justice system and the civil justice system. And what we're talking about here is the criminal law context. And like you say, the law in our Criminal Procedure Act very clearly states that an accused may not be named. So in other words, no details of the accused, including his name, anything that might identify him, as well as any details identifying the nature of the offence, may be published. And publication is a very, very broad concept. So may not be named or any information published until he has pleaded to the charge. Now, this is restricted to sexual offences, and the only other offence that it's restricted to is extortion. So as an example, if someone were accused of murder and appeared in court today accused of murder, their name, their details, where they live, what the nature of the crime was, would be allowed to be published in the media, on social media, etc. So their identity would be revealed. Yet, if someone is accused of any type of sexual offence or extortion, those are the only two crimes, then if somebody does publish their details before they have pleaded to that charge, they can be criminally charged. And that's the very serious consequence, that anybody who publishes, whether it's someone in the media or someone in the public, publishes the details of an accused before they've pleaded, then they are liable to a criminal offence. Well, they can be charged for a criminal offence and potentially convicted of a criminal offence. Now, that is very different in the civil context, and we can talk about that a little bit later when we talk about defamation. That's a very, very separate thing. The issue here is that the consequences of breaking this law are that someone could actually get a criminal record if you, as an individual or representing a media house or literally an individual who names an accused person, and that goes for both the complainant, the victim, and anyone else in someone who might be supporting that person or maybe a family member, or just a member of the public who happens to know that someone is an accused in a sexual offence. And like you say, what's very important is that pleading can sometimes take up to 2 years, sometimes even more, before the details of the accused can be published. So it's the only offence where an accused person is protected right up until they plead guilty or not guilty to the offence in court.
Wow. And I mean, using the term protected is such a strong phrase. I want to ask, just so that we know, when you say pleading, it means they're coming into court and they're saying, I plead, guilty to this thing or not guilty.
Right.
And I also just wanted to ask, so how can it take so long? I know when I first did this, it was just all new to me. I thought, they appear, and once they've appeared, because it's the first appearance that must happen, I just assumed, from the movies, that is what's happening.
Yeah, so it's very different because, especially in sexual offences, very often an arrest takes place quite soon after the alleged event has occurred. So technically, the National Prosecuting Authority will only enroll a case onto the court roll, and that means that the accused must appear in court if there is what we call a prima facie case, which is on the face of it, there is enough to link the accused to the offence with which he has been accused. And he will then appear in court, and exactly what you're saying, the first appearance. But very often, because of sexual offences, there are aspects of the investigation that take time. So in other words, further investigation, further statements need to be taken, medical evidence, the JT8, sometimes there's DNA, that's outstanding. And until the investigation is complete, only then will the accused be asked to plead. Now, it's not unusual in all other types of offences for that process to take quite long, because very often in serious cases like murder and rape, those cases are heard in what we call the regional courts, which are one up from the district courts, and it's only until the investigation is complete that the accused will then be asked to plead. And because sometimes these investigations can take a long time, it can take up to 1-2 years before that happens. So no, the accused in all matters is not asked to plead on their first appearance or on their second appearance or sometimes even their third appearance. They wait until the investigation is complete. But the difference, of course, is that for other types of offences, and I'm sorry, I'm repeating myself, for murder, etc., after that first appearance, they can be named. For fraud, armed robbery, some of the most horrendous offences we have. But in a sexual offence, no matter how serious or so-called minor it may be, the accused may not be named until he has pleaded.
And so it's almost as if sexual offences and extortion, because you have been singled out.
Yes.
Out of all of these other crimes, we can't say the names of people linked to these two specific crimes.
Yes.
Which is just weird. Chrissy, I want to ask you, we've spoken about this issue before. The Women's Legal Centre has dealt with these types of cases before. Your context around this was that because the law is so restrictive around naming perpetrators or accused in sexual assault cases, it almost forces victims to go to social media for some sort of justice. Can you explain some more, just like why do women feel the need to turn to social media?
So I think, Lenina, that there are various factors that come into play in addressing this. I think, like Bronwyn pointed out at the outset, is that we must be mindful that there are two kind of avenues in law in which this takes place. So in a criminal sense, which Bronwyn has outlined now, but also in a civil sense. And so to speak to the question about why women speak out is that in the past, so over the past 3 to 4 years, in relation to many women who have come through the doors at the Women's Legal Centre and sought our legal representation and assistance, is that we've seen various reasons in why they've actually come to us in relation to them speaking out. What we see is that women, when they do experience violence, whether it be within a private or in a public setting, within their homes, within the workplace, at schools, at churches, in various spaces within their communities, they often face secondary victimization in the sense that oftentimes their community, family members or friends do not believe them when they do report violence. They experience secondary victimization and trauma at the hands of police officials who are supposed to be helping them, who further do not believe them, or provide incorrect advice or assistance, or assistance that lacks a sensitive approach and understanding to the various needs of survivors. And thirdly, we've seen that where women have gone through the court's processes, they have also endured secondary victimization. And we understand that the court's process itself, you require access to resources and financial capacity in terms of legal representation. And so what this does is that it's created a sense of disbelief and a lack of trust within our justice process, both within the criminal justice process and other courts who are supposed to be protecting women. And as a result, this has resulted in women therefore seeking other ways to kind of protect each other. Now, I want to also just say that for a lot of the backlash around women publicly naming their perpetrators is this negative kind of stereotypes and stigma that women are salacious, that they are just gossiping, that it is untrue, or that they do it to be vindictive.
Yes.
And actually the opposite is true, because women for years have been warning each other about known perpetrators in their communities, in schools, at nightclubs where women say, let's go to the bathroom together, right? In spaces that we feel unsafe. Even in families where there are known perpetrators, in families, we create certain networks for each other to warn each other, even in church spaces. What has happened is that over the past few years, social media has evolved. And where women used to take to the streets, to the community, to each other, social media kind of has elevated these forms of protest and disturbance, in the sense that now you're able to harness support, mobilize, and create awareness on a large public platform and scale. And so, for example, within university spaces, we've seen this play out over the past few years. And what it does is create attention across provinces and across the world. And we've seen this with movements such as the social Me Too movement, social movement Me Too.
Yeah.
And so what social media has done is created this bigger platform for women to speak out, but the consequences thereof have been devastating, in which we have seen the very courts designed to protect women being used to further harm them and silence them.
Yeah, and so the consequence, and there have been legal consequences, which brings us to why we are here today. The Women's Legal Centre has now launched the application to challenge the Criminal Procedures Act, and to challenge that portion that says we can't name an accused until they have pleaded in sexual assault cases. Bronwyn, before you answer that, I just want to ask, when you were running through the pleading could take up to 2 years. Now, our prosecution rate and conviction rate for sexual offences is very low anyway, below 10%. The conviction rate's below 10%. And so just for the audience, I always give this example, there's over 50,000 sexual assaults that are registered with the police, and less than 5,000 of those end in conviction. So over 90% of those cases are not followed through, don't end in conviction. At what point in there at what point does pleading happen? So if a case is dropped, say a large percentage of cases is dropped, does that mean it doesn't even get to pleading stage? I'm saying over 90% of these cases, we actually just can't name the perpetrators.
I think that's a very good point, because like you say, over 50,000 cases of sexual offences are reported every year, and that includes all types of sexual offences. So it's both rape and sexual assault and attempts. And like you say, at the moment, the latest statistics show that only 6,000 of those cases are prosecuted. In other words, they require the accused to plead. When we say they're actually prosecuted, that a lot of cases actually get onto the roll. In other words, the accused will appear, but it's only until he is asked to plead will that be considered a prosecuted case. Because once somebody pleads, it means they are entitled to a verdict. It means that they're entitled to be found either guilty or not guilty. And only about 6,000 cases are prosecuted. 4,000 roughly at the moment result in a conviction. So actually our conviction rate is going down. Lesser cases or less cases are being prosecuted every year. Yet, if I may say so, the NPA states that their conviction rate is higher in the last reporting year than it ever has been. It's up to 74.5 or 75%. But that doesn't mean that the success rate is better because they are actually prosecuting less cases. But to get to answer your question, pleading only happens once someone appears in court. So very few cases are even finding their way into court. So the vast majority, like you're saying, 90% of cases, the accused is never in the public realm. And details.
So it becomes illegal to name accused or perpetrators of sexual assault in over 90% of cases that are reported to police.
Absolutely.
And it just gives us like a scale of like what the situation actually is.
And when you say illegal, it's illegal, but even more seriously, it's criminal. There is a criminal charge attached to it. So you can be arrested and prosecuted yourself if you were to name someone before they've pleaded.
Okay, so let's talk about that. Let's talk about this case that has now given rise to the challenging of this legislation.
Yes. So the name of the case of our client is Caroline Peters, and the reason I name her is because she is very comfortable with being named, so I name her with her permission, and she has spoken out publicly about this matter. Caroline Peters is an activist, a long-time activist in the field of violence against women and gender-based violence, has done phenomenal work on the Cape Flats, and one of the things that her organization does is provide legal and court support to complainants or victims of sexual offences. And the fact of this matter was that she was providing support of that nature to a victim of a rape and attended court with her in 2021. And as a result of being in court, she took a photograph of the court roll, which is placed outside of the courtroom with the name of the accused and the offence with which he was accused, which is rape, as well as taking a photograph of his back when they entered the court. And she posted both of those photographs on her Facebook page. In other words, naming the accused, publicly naming the accused before he had pleaded. It's important to note here that Caroline Peters was not aware that this was a criminal offence, and although that is not a defence in law per se, one has to look at the rationale behind the law before one looks at criminalising someone. So we are arguing in that matter that the very law that criminalises Caroline Peters' behaviour really is unconstitutional because it criminalizes her. What happened, just as an aside thereafter, is the accused in this matter brought an application in terms of the Protection from Harassment Act and got an interim protection order against Caroline Peters for breaking the law in terms of naming him before he had pleaded. So he used another piece of legislation to silence Caroline around naming her. And technically, the law had been broken by Caroline. We successfully defended the protection order, the interim protection order, but the criminal charges against Caroline Peters still stand. And the irony of it is that this happened in late 2021, and the accused in this matter, as far as we know, has still not pleaded. So for the whole of 2022 and into 2023, he has not pleaded. And the deeper irony of that is that when we have launched this application to challenge the constitutionality of the matter, we are the applicants representing Caroline. The first respondent is the Minister of Justice, because the Minister is responsible for the legislation we are challenging, which is Section 1542B of the Criminal Procedure Act. But we have also named as a second respondent, the accused, and we cannot name him. We actually have had to redact our pleadings because he has still not pleaded, so we cannot name him in these legal proceedings.
In the court papers itself?
In the court papers themselves. In fact, I've got a copy of it in front of me, and his name has all been redacted because we are still having to comply, because if we were to publish his name and in our pleadings name that he is an accused of a sexual offence, which he is, we would be breaking the law ourselves as the lawyers.
Wow. What I want to sort of also ask, like, so, just coming back to the protection of perpetrators, I think, and I don't know if it's fair to ask this question, and you may or may not have an answer about it, but like, when you say we have to go, like, what's underneath this? We have to sort of question the legislation. It's like, how do we get to a point where only sexual offences have this restriction, and not murder, and not theft, and not like a whole lot of other I want to say kidnapping. Even kidnapping.
Kidnapping, absolutely. So first of all, I'll give you a technical answer. A technical answer,
Bronwyn,
yes.
You know what? We need to take a short break.
Right.
So we're going to have to answer that when we come back.
Fine.
We're going to take a short break, but we'll be back with more after this. Welcome back. You're still watching The Womxn Show, and we've been having a really interesting discussion about the legality of naming accused in sexual offences and rape cases, which is currently illegal and a criminal offence before they have pleaded. And so I've got the Women's Legal Centre with me because they are now challenging the constitutionality of the Criminal Procedures Act, which restricts or prohibits the naming of perpetrators in sexual offence cases and rape cases until they have pleaded. And I will just add, that process can take up to 2 years or more. Still with me in studio is Bronwyn Pithey, who is an advocate at the Women's Legal Centre, and Chriscy, Blouws. And so, Bronwyn, before the break, I had asked you, we had been talking about how it is only, this restriction is only for sexual offences and extortion and doesn't apply to murder, doesn't apply to kidnapping and theft. If someone commits those crimes, you can name them the next day on social media or in the news. But with sexual offences and with extortion, you can't. And I was asking, are there any reasons, historical, what's the background to sexual offences being singled out for this?
Yeah. So first of all, what we're doing is we're challenging the constitutionality of it and basically saying that we are arguing that it's discriminatory and that it's irrational. So those are really what we're saying, is that it discriminates unfairly between types of offences and effectively silencing complainants and those that support complainants in rape and sexual offences matters from speaking out. So, and we're saying it's irrational. Now, the reason we say it's irrational, and as soon as we say it's irrational, we effectively require or request the minister, who's the holder of the legislation, to explain why there is that differentiation and that discrimination. Because one can discriminate in law, it just has to be fair discrimination. And we're saying this is an unfair discrimination. So we're throwing the ball back into their court and saying, this law makes this distinction between types of offences. Why? Now, you've asked me why I think so.
Yeah.
So I can only surmise, and based on what the history of a provision like this is, and coupled with another type of offence, extortion, we think that it probably has something to do with the very deep ingrained stereotypes and myths around sexual offences, and that women are known or presumed to lie about sexual offences, and that the protection of the reputation of an accused person in a sexual offence overrides the importance of naming him until the National Prosecuting Authority believes that they have enough evidence to proceed with the prosecution. So it's, unless we're 100% sure or 90% sure that this man did it, we're going to protect his identity, because we're going to err on the side of women lie. They may be not telling the truth about the whole thing. We have to protect the identity of a man in order to protect his to protect his reputation. So I think it's a discrimination. If you look at extortion, there's an element of, I would say probably an element of being not really believed. There's an element of really, you could be lying about something. There's a disbelief. There really is something that we can't quite believe about the allegation until we're absolutely sure we've got enough evidence. And so we think that that's where the distinction is made.
Okay, and I'm just going to bring in here, because this was, one of the most fascinating things for me, that disbelief is also rooted in law. We had a cautionary rule, right, that initially said women lie about sexual assault, so we have to exercise caution in investigating this. And so you make a lot of sense in terms of thinking of how this follows on from that, from this sort of belief that women lie around sexual assault, and let's put all these protective mechanisms in place to protect men who are accused of. So that makes a lot of sense, and I'm excited to see sort of what the responses are going to be. I want to also, in the court papers and the reasons for challenging the constitutionality of this, there was something around, there were very specific reasons given motivating for the naming of perpetrators before they plead, right? And one of the things that I found so interesting, Chriscy, and I think this speaks to what you were saying earlier in terms of women being able to tell the story, women being able to protect themselves through naming. One of the central messages in campaigns by government, even by the Department of Justice themselves, are, if you are assaulted, speak out, right? Don't be silent about it, etc. And I've read through the court papers, you list specifically quite a number of campaigns through the years which encourages women to speak about this, and yet legislation prohibits that. So I want to just ask if either of you can expand on this disparity in the language and messaging.
Yeah. So I think, just to elaborate on what Bronwyn was saying as she was speaking around Caroline Peters' case in a criminal context, similarly so within a civil context, the Women's Legal Center is trying to holistically kind of undo the harms that our laws and perpetrators are conducting against survivors of violence. And why I say this is that, like you said, there are various campaigns by our state around women speaking up. There are various campaigns within communities, within religious institutions, within university or education spaces that says, let's speak up and protect victims and survivors of violence. In relation to naming, what we then find is that the very laws, the courts, are used actually to silence women. And so the campaign that we're working around, both within the criminal and a civil context, is to say that it is irrational and actually not reasonable to use laws designed to protect women to further harm them. As you mentioned, this cautionary rule exists, but it's a law and principle that was supposed to be and has been done away with in our law. But it's an idea that even though the law has done away with something, we still haven't outdone that perception within our communities and with our people. And so it's with the way that we practice within the Women's Legal Center and looking at laws and processes within an intersectional manner, that means that we look at the purpose, the nuance, and the approach of the law itself. And so therefore, the work that we do around women being able to name really looks at the purpose and the context that the laws were created. So it looks at the root cause or the issue that the law was designed to deal with, not being dealt with in this particular way. So for example, in our naming of perpetrators work in a civil context, we have seen clients being sued in terms of the domestic violence courts, protection from harassment, domestic violence, protection from harassment courts, but also within defamation matters. And so we look at the purpose, if you look at the purpose of a domestic violence court, the purpose of that court was the design to protect marginalized and vulnerable groups, being women and children. Yet women are being targeted in the court. And so the rationale doesn't exist. It really is irrational to then target a victim of violence using the same court that was designed to protect her. And so these are some of the concepts and kind of the mission of the work that we're doing, both within Caroline Peters' case in a constitution, in a criminal context, but also within a civil context, because we also have to look around issues of access. When we speak to intersectionality, we understand that violence across the board affects women, but we understand that you experience that violence differently based on the intersections of race, your religion, your culture, your socioeconomic access and background. And so these are some of the concepts that we're working to highlight throughout this work as well.
Yeah, and just to talk about that intersectionality, because I didn't want to come into that, and access to resources. If we look at, not everybody can afford to defend themselves in a defamation case. So if we have a case here where someone who doesn't know that it's illegal to name a perpetrator, names a perpetrator, and then gets sued, in civil court for defamation, can't hire a lawyer.
So the consequences are devastating in a criminal aspect. Like Bronwyn has outlined, you can be charged and you can have a criminal record. And in a civil context, it's as devastating because it has the potential to financially cripple women. And that's what we have been seeing happening over the past few years. Women in defamation cases, either where they don't have access to legal representation and so don't appear in court and default judgments are granted against them in defamation matters, or where they do have legal representation but the court process takes long. Sometimes settlement agreements are reached. And in instances, we have seen women be sued with up to 100,000 Rand, up to 300,000, 400,000 Rand in damages for defamation matters because they have spoken out. Some of these women are students. So the devastation of that financial crippling, but also the fear and the chilling message that sends to all other women, which is one of the biggest kind of arguments we have placed before the courts, is that what such cases do, and in the instance of Caroline Peters, for example, this is an activist within a community. And so if we silence an activist in the community, what fear and message do we send to all other women within the spaces?
I just want to also ask, when you spoke about, I found it really interesting, you're speaking about the purpose, nuance, and approach of the law, and the context within which it was created. And so some of these laws are really old. Right? They were created a long time ago. And so we're also asking whether it is relevant right now, given the information we have, given the statistics that we know around the prosecution rates and conviction rates, and South Africa having some of the highest rates of rape and gender-based violence in the world.
Yeah, and I think it's important to also highlight some of the other aspects in our papers that we detailed. Is that not only do we find that the messaging from government is contradictory, speak out, don't remain silent, let it be, communities must speak out, don't protect, don't hide perpetrators, etc. Yet on the other hand, we have a piece of legislation that criminalizes people for doing that. That's what we've been talking about. But the other aspect, which is really what we were trying to say as well, is that if you name, like in any other matter, an accused at the time which he is arrested and appears in court, that can actually assist an investigation. And so that's a positive thing that is being lost. So, in other words, what we detail in our papers, for example, it could very easily, especially in sexual offences matters, it could alert other potential victims or complainants to come forward if they are familiar either with the perpetrator or with the modus operandi of the perpetrator. Secondly, very, very often, and we've seen this again and again, where children are victims, what it can do is that it encourages other people to come forward. When they see one person coming forward, very often other victims then come forward. And a very good example of this is a matter that is running in the Johannesburg High Court, where Paul Kennedy, who was a senior advocate who was before the court, hadn't pleaded for as long as a year at least, and then committed suicide before he had to plead, so he was never named. His co-accused in this matter is continuing facing the offence. And as soon as his name has been made public, a lot more people have come forward.
Oh, wow.
Now, that is there
because
really...
he was deceased, so they
because
could be his
he was deceased, so he could be named. And there's a lot more information that has suddenly come forward because other people now know about it. But until this period of time, or for this long period of time where he couldn't be named because he hadn't pleaded, no one was aware, or the public were not aware of who the accused were. And this is someone who clearly offended or allegedly offended against a number of people and involves a lot of child pornography, etc. But that goes, for, say, serial rapists. You don't even necessarily have to only name the name of the accused, but also the details of the offence. Because if it's an unknown perpetrator, you would maybe very, very well come forward and say, well, actually, this did happen to me in very similar circumstances, can add to the investigation. So we're not only saying it, and I think a lot of people think, well, we just want this to be able to, humiliate and expose alleged perpetrators. And I don't think that that's a fair assessment. I think it really is there as well to assist in the investigation. The example that I use often is, the man who's been accused of setting fire to Parliament. His identity was all over South African newspapers the day after he was arrested. And he still hasn't pleaded either. Yet we all know who he is. We all know what he's accused of, etc., etc. So I'm just saying that the ironies are deep, that when we have a sex offender, we know nothing about them until they plead. And I really do think that this has to do with the lack or the belief that women are untrustworthy, that we can't name perpetrators until we're absolutely sure, well, this is what the law says, and that we can trust what she says may actually have some veracity.
Definitely, but I'm just saying, this is my personal opinion, but what is also emerging is that, this other belief that sexual offences are not that bad and not such a big deal, in the way they are getting away with it, and are still not being able to name. So that's just a feeling that's coming up for me. I want to say, you're speaking about the man accused of setting fire to Parliament. In the court papers, there were also that there have been cases where perpetrators of sexual assault were named. And so you did give some examples. Yeah. And I just wanted to sort of, it's happened in the media.
Yes. I think that's also true, is that actually 90% of the time the media does not name perpetrators or alleged perpetrators accused of sexual offences because they know the law. But there have been a number of very high-profile cases, one of them being the rapist who was known with the Dross, the Dross rape. He was named immediately by the media, and there were some media houses who said they won't name him because they know that that's what the law is. But there were a number of media houses that did name him, not only named him, but actually published his photograph as well, the man who was accused, and has subsequently been found guilty. But as far as we're aware, there have been no legal consequences against those people. There are no criminal charges against them, yet Caroline Peters sits with a criminal charge hanging over her head.
Very interesting, ladies. I mean, we could discuss this for a whole another hour, but we are sort of in the last 4 minutes now. I just wanted to ask, so what does this mean for us who are sitting at home, for victims of sexual assault? I know, Chrissy, there was just some context around knowing our rights, knowing what the risks and consequences is. The law, it is still illegal. It is still prohibited. Where do we stand now?
I think a takeaway for this is understanding the difference, and like you said, rights awareness and just being educated on where things fall in law. Because criminally, yes, but in terms of the civil law, for example, if you do name someone outside of this criminal justice process, there are valid defenses to it. And I think that a lot of women are fearful of the consequences of being found guilty of defamation and having seen the financial cripple that they could incur. But the reality is that there are valid defenses to naming a perpetrator, even on social media platforms. Also, for example, understanding that there are consequences for third parties who share a name. So being aware that even if I come across something on social media and I forward or retweet or share the post, I could also be charged or sued for defamation. So it's understanding where issues fall within the law and what the various consequences are, but not to feel necessarily defeated by it. We have a very long way to go. As Bronwyn and I have both just highlighted, we're working on this in a holistic manner, both within the criminal justice system and against representing women who are being sued in terms of civil law. We have a long way to go. We don't have the judgment that sets all of this and turns it on its head as yet, but understanding that there is legal representation available at certain organizations, understanding that there are valid defenses to various instances, and understanding then also how to support other women and how to come forward. Like Bronwyn said, one of the highlights of these cases that we've seen both in the criminal matters and civil matters is that the biggest thing about naming, and we've seen this nationally, for example, with the Harvey Weinstein case, is that one of the biggest things about publicly naming a perpetrator is that it does bring about additional evidence and witnesses. And that's a big takeaway from this, is that it actually has proven to garner the support, to create the movement, and then to create healing and kind of solidarity for women in a sense.
Definitely, you know, and actually, as you were speaking, I was thinking about the international cases like Harvey Weinstein, Bill Cosby, Larry Nassar, you know, where there have been cases, and R. Kelly also, where there were individual sort of cases being made, and individually those voices were not strong enough to lead to prosecution. And so we see that in sexual assault, there is strength in numbers. There's it shouldn't be, but there's credibility in numbers. And so, you know, it makes a really strong case for naming. We are out of time. I want to thank you so much. I'm really excited, and I just want to say there is still a long way to go, but the fact that this is happening, this is how I keep my spirits up. And so the fact that this is happening is progress. And so I want to thank you so much for the work you do, and thank you for being here today.
Thanks very
Thank
much.
you for having us.
Thank you.
We are going to take a short break, but we'll be back with more after this. Welcome back. You're still watching The Womxn Show, and we have been speaking about the naming of perpetrators in sexual offences and rape cases before they plead, and the consequences for women survivors and their supporters if they identify perpetrators on social media. Now, we are almost at the end of our hour together, but before we go, we are going to play a video produced by the Women's Legal Centre, profiling organizations that work in gender-based violence. Let's have a look.
Gender-based violence is a whole of society's problem. If you see something, say something. Hello everyone, my name is Caroline Peters. I am the Executive Director of an organization named Colors Foundation. We are based in Bridgetown in Athlone. So what do we do at Colors Foundation? We have a few programs, and I want to start with, we have Access to Justice program. We support women through the justice system. As we know, the justice system is very daunting for women. So we support survivors of sexual violence, families of femicide victims through the justice system. So the Access to Justice program would be that. We would petition for no bail for perpetrators. We have demonstrations. We, in fact, also have stakeholder engagement meetings regularly for the area, so that helps us with our Access to Justice program to assist women through the program. So we have, I always say, champions in all of the departments for access to justice, like the NPA, DOJ, DSD, Department of Health, and every other department. We have a champion that belongs to the Access to Justice stakeholder gatherings that we arrange. I'm saying that we all have a role to play. If you see something, you say something. We do not call out, even as men, and we do not, as women, occupy. I always say to the males in my family, I do not occupy the spaces that you do. You have a role to play. Because there where you say, not in my name, brother, and you mean it. And the same for us as mothers, the language we use with our boys, with our girls. How do we, gender reveal parties is another thing. We all falling into this. I don't know what the heck gender reveal parties is about. It was probably a European thing, and then here it comes to South African. Everybody's into this gender reveal parties. We pop balloons and outbursts, pink confetti or blue confetti already. When the child is born, we put him into a box. And that is the way the child is going to be socialized. Are we intentional buying our boy children dolls? And then we say we want good fathers. Have we helped him to get to be the good father that we say we want him to be? Do we pick him up when he cries and give him the same attention and love and affection? But mothers, we say, if I have to be in a room with all of you women and say, what type of man would you want? You would say sensitive, loving, honesty. Do we grow those men, mothers, because we raise those boys? Everybody would put up their hand when we say, do you know someone that's in a violent relationship? We will all raise our hand. The perpetrators is also our boys, our fathers, our brothers, So again, it's going to take a lot and a whole of society, but I believe that if we work together, we can eradicate gender-based violence.
That was a short video produced by the Women's Legal Center, profiling an organization working in the GBV sector. And that brings us to the end of our hour together. Thank you for joining us. I'm Lenina Rassool. Goodbye.